Today we're here to talk about impeachment, and we have as a guest Judge Edward Ray. I'd like to give a little bit of information about Judge Ray and his distinguished career. It's my privilege to introduce a distinguished judge, educator, and scholar. A federal judge since 1968, Judge Edward Ray is Chief Judge Emeritus of the United States Court of International Trade. Judge Ray served as Assistant Secretary of State for Education and Cultural Affairs and administered the Fulbright Scholarship Program. He was Chairman of the Foreign Claims Settlement Commission of the United States by appointment of Presidents Kennedy and Johnson. By designation of President Carter, he became the first Chief Judge of the United States Court of International Trade. He has received more than 20 honorary degrees. After 23 years of judicial service, he retired and returned to St. John's Law School as Distinguished Professor of Law. Professor Ray has done so much that it was difficult to condense everything he has done in a short introduction. I am pleased to have as a guest someone who grew up in Brooklyn, went to high school in Brooklyn. The topic that we will talk about today is impeachment and the Constitution. Judge Ray has published articles that reviewed impeachment and has lectured about the Constitution and impeachment. Professor Ray recently spoke at Columbia House to a group of lawyers and judges about impeachment. For me, it was an educational experience. As a retired judge, Judge Ray may not wish to express his opinions about certain issues. However, he will help us as an audience express and review what criteria we may want to use in looking at the impeachment issues. And before we begin, I'd like to have Judge Ray here introduce himself a little bit and talk about what he'd like to talk about.
Well, as I said, Erwin, I'm delighted to be here. I'm pleased that you enjoy the lecture. You may recall that when these very fine lawyers asked me, what do I think is going to be the end, how is it going to conclude, and all of that, referring, of course, to the present impeachment situation that, of course, has attracted not only national but international attention, I said, frankly, I should like to discuss with you the constitutional provisions and the impeachment process. The others are a question for the appropriate body that has to pass upon the factual issues and apply the law to the facts as they are found.
Okay. I know that when you spoke, you gave each of the constitutional provisions, and maybe that's something you could do now so that not only you know them, but the audience and any school children who are listening can then have something to talk about to their teachers.
Well, I do agree that when we talk about the Constitution, it's well to know what does the Constitution actually say. What does it provide? It is the supreme law of the land. And there is an impeachment clause. Now, whether or not we know it by heart or by memory, I want to prove to those who listen that I'm reading the precise words. Section 4 of Article 2 expressly provides the President, Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Now, so many have heard those words so many times, and I will tell you that everyone is right when you hear that they are not defined in the Constitution. Well, that should not be surprising, because the Constitution is written in general terms. Magnificent words, due process of law. In the 14th Amendment, for example, nor shall any state deprive any person of life, liberty, or property without due process of law. I can think of no greater words of freedom. But sometimes we don't really want to define them, because in the process of defining, we are delimiting. That's what definition really means. So they acquire meaning in their application. So the great responsibility is the responsibilities of those who apply these words. For example, you referred to my expertise in impeachment. In all candor, most of my writings, and a recent article that brings the topic up to date, is on the impeachment of Article 3 federal judges. And there is an analogy for this reason. And it is relevant for this reason. Article 3, Section 1, after establishing the judicial power in one Supreme Court of the United States, provides that the judges both of the Supreme Court and inferior courts, jokingly I tell students that we may be judges of inferior courts, but not necessarily inferior judges. And inferior courts shall hold their office during good behavior. And it goes on to provide that their compensation shall not be diminished during their tenure. So that confers a good behavior tenure upon Article 3 federal judges. These crucial words, good behavior, also are not defined. So we start off with
I was going to ask you, I think that at one point, so many of the words in the Constitution are vague. And, you know, even now, how would one determine good behavior?
Good behavior has acquired a definite meaning by virtue of the manner in which it has been applied with relation to the 58 documented cases of impeachment of federal judges. Of the 58, 14 have actually been tried after having been impeached, and 7 were in fact removed from office. So we have a pretty good idea of what is conduct that is not acceptable and doesn't come within the constitutional words of good behavior. Very quickly, this is an area that has been of great interest to me. Until 1701, judges could be removed at the pleasure of the monarch. The king could have removed the judges, and that was intolerable. You cannot have a judge who has no status or tenure. That goes to the very heart of independence of the judiciary. So in 1701, in a very important act of the Parliament, it became, those words, originally they were in Latin, they were de bene placido, which means at his pleasure. They were changed to also in Latin, translated into good behavior. Very few Americans, I think, know that one of the charges against the king in our Declaration of Independence was that in that he did remove our judges at his pleasure, really violating the Act of Settlement of 1701. So there are words that are not defined.
Because sometimes, you know, even recently, there were cases where federal judges were criticized for decisions, and, you know, some political party said, well, that judge acted inappropriately, even though the judge acted according to what he felt the law was.
Well, that is the very heart of independence. You always have an appeal. You have the right to appeal. But it's interesting to note that since 1980, it is possible to start a proceeding against even a federal Article 3 judge whose behavior doesn't come within the standard of good behavior. But that's a somewhat different question, because although it casts some light upon the problem that is before us, it is only analogous. And that is the very difficulty of our subject. We do not have a specific situation that covers the particular case. So what we ought to know is what the constitutional provisions expressly provide. So why don't we start with having mentioned the impeachment clause, which is found in Article 2, Section 4 of the Constitution. Let's go to the responsibilities of the legislature. So in dealing with the House,
right,
which is found in Article 1, Section 2, the last clause of Section 2 says that the House of Representatives, shall have the sole power of impeachment. Those words are crucial, and sole has been interpreted by the courts to mean sole.
In that particular article, when it says that the majority of the members, so it doesn't require 2/3.
Majority is all that is required for a president or anyone to be impeached. Now, the Senate is set forth in Section 3, and the last clause of Article 1, Section 3 says, and this is now the crucial question that you'd like to have me address, that the Senate shall have the sole power to try all impeachments. Then it goes on to say, with relation to the impeachment of a president, a very serious thing, when the president is tried, the Chief Justice shall preside, and no person shall be convicted without the concurrence of 2/3 of the members present. Now that shows the great wisdom of the founders. First of all, if it's the highest officer of the land, they wanted to dignify that. They wanted to stress the solemnity of it, and required that the officer who shall preside will not be the presiding officer of the Senate even, but the Chief Justice of the United States. All of us recently have had the marvelous experience of seeing how perhaps the entire proceedings changed the moment the Chief Justice of the United States walked into the Senate chamber. He took an oath. He administered an oath that brings to the attention of the world the solemnity of the occasion, the importance of the occasion.
In the Senate, when Chief Justice Rehnquist presides, is he there as an advisor, or does he, tell them, well, you can do this or you can't do that?
No, he's only there as presiding officer, and I want to stress that the situation of impeachment is what we would call in the law sui generis. I, as a law professor of so many, many years, do not like to have words used loosely when it deals with very serious legal concepts. Sui generis means unique. We analogize it to all sorts of things. It's really not helpful, because sometimes the analogy causes us to think of something else. The Constitution says a few other things about impeachment to show you that they gave a great deal of thought to this particular very serious matter. The last clause of Section 3 of Article 1 says that a conviction shall not extend further than to removal from office. And then it says, and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. It continues, the language of the Constitution. We should always keep that in mind, because it is that is the guiding light that we must follow. But the party convicted.
Professor Ray, on this, I'd like to stress the Constitution was written more than 200 years ago, and it's still effective as law in this country. It's amazing that they had the forethought to write a document that effectively is working even today.
This is an extraordinary document prepared by extraordinary individuals who, as we have been told by great justices of the Supreme Court, they were writing a document for all time. And it is well for us to remember that we are one of perhaps the oldest living republic in the nation having a written constitution. And so the document is extraordinary, and that's why its specific language is important. And it says, but the party convicted shall nevertheless be liable and subject to indictment, trial, and judgment and punishment according to law. So we have to remember that the question is, should we remove this individual? This is a removal provision. It really doesn't deal with punishment. So there are other provisions that have been mentioned.
Judge Ray, one of the things that I find is in the Constitution, it doesn't say that it's a criminal trial. It allows just for removal, and I think that's something that also is significant, because